Hi, I'm Dr. Mark Student, and together with ChiroSecure, we're going to bring you some incredibly timely information that has to do with the documentation and reimbursement world. There are so many things going on and so many changes that if you don't understand, you could find yourself one, not reimbursed, two, audited, or three, even worse, with a lawsuit. So, what I first need you to understand is how the system works specifically with the courts. And unfortunately, most doctors don't understand that we're a country of laws with certain rules, and the carriers use those rules to leverage you to neither not pay you or to get your money back threefold. I'll talk about that in a moment. So, and everything boils down to documentation. And I can tell you when I practiced, and I'm not suggesting anyone do this. I saw 650 visits a week. My documentation was not what I would even accept as acceptable today. I wouldn't do it. What I did was just not right, but I didn't know any better. No one ever told me. So documentation, as I evolved and grew up as a chiropractor, I realized that for every area you touch in a SOAP note, you need a symptom, an objective finding, an assessment, which is your diagnosis and your prognosis, and the plan, which is what you did for the patient or what's changing. You need that for every single visit. Oh, I did the diagnoses on the first visit. I don't have to do it again. No, 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 no. That is incorrect. You need a subjective, objective finding, assessment, diagnosis, prognosis, and plan what you did on every single visit. Non-negotiable. Non-negotiable. If you want to stay out of trouble, you do those. And I just did a statistic last Sunday, which was a few days ago. And as 3 out of 4 of my kids are attorneys, I get on the lawyer search engine. And in the past 4 years, 1 out of approximately every 60 to 100 chiropractors have been sued in federal court. That is just an overwhelming number. I mean, think about that. In any industry, 1 out of 60 to 100 are sued in federal court. This isn't, oh, the sky is falling or anything like that. But the carriers have a program called Fraud for Profit. And they want your money. And they want it threefold. And they don't care if they take your house, your office. They don't care. They're heartless. It's just business. And they're really good at this. And they spend a lot of money to figure out how to make money from you and get it back. So if you use my formula for the SOAP notes and Mark's hard rule, for every area you touch, you need a symptom, a clinical finding, and a diagnosis. Symptom, clinical finding, diagnosis for every area you touch. And that goes on every SOAP note. You will keep yourself out of harm's way, provided you do all the other things right. Now, so what the carriers do, and you have to understand the game, and it's not just the carriers, it's the licensure boards. Oh, I'm afraid of the carriers, the big bad wolf. They're going to huff and puff and blow my house down. The number one area where doctors get in trouble is on cash patients, not insurance patients. If someone claims to the insurance company, they're going to make a financial calculus of what it's going to take to go after you, and are they going to make enough money? So you're kind of insulated there. Especially if you're seeing about 100, 120 patients a week, it might not be worth their while. But the number one area of complaint are cash patients. Who's the only person they have to complain to? It's the licensure board. That's it. It's the licensure board. And by law, every complaint has to be investigated by the licensure board. They're always understaffed, and they're always quick to judgment as a result, and they rarely judge in your favor. So they're going to come after you with a vengeance. And instead of saying, we want your money, they're going to say, we want your license. And that's what they do. And I've been through this with too many doctors where they've come after their license, and they take your money, they give you a steep fine. So you don't want to get stuck between anyone's crosshairs. You don't want to go to jail. You don't want to lose your license. You don't want to get audited. Look, I'm married 48 years. I don't want to win the fight with my wife. I just don't want to have it. That's it. I just don't want to have it. And you don't want to have a fight with anyone in practice when it comes to your license, your money, because it's really easy to. Sorry, my phone was supposed to be on mute. It's on mute now. I apologize. Okay, so it's really easy to get yourself stuck in the crosshairs. It's really easy, and we're going to ensure that you're not. So follow the hard rule. For every area you touch, you need a symptom, a clinical finding, and a diagnosis. But should you get to the carrier's crosshairs, here's what they do. The mantra for the carriers is predetermined treatment plans. That's their mantra, and it's been that way for many years. Because 3 or 4 of my kids are lawyers, I get to use their search engine called LexisNexis or Westlaw. Just like we have PubMed and Ovid for research articles, they have law review searches. And I could look at legal cases, and I actually read them. And then there's something called PACER, which is federal complaints. You get to read the full context of the complaint. And the predetermined treatment plans are the mantra of the carriers, meaning 98% of your patients get x-rays, 97% of your patients get cervical and lumbar adjustments, 94% of your patients get cervical thoracic lumbar, 92% get E-stim, and on and on and on, and it's considered predetermining and not patient-centered. So if you're using muscle test and range of, oh, by the way, if you're not x-raying your patients, well, then they get to say it's basically upon palpatory or subjective findings. And when you're using static and motion palpation, that has failed intra and interrater reliability. So therefore, they're saying it's purely investigational, subjective, and it has nothing to do with being patient-centered of what you found on the patient, and you're doing is it a scheme to defraud the insurance companies. So the insurance companies will typically have an 80 to 100-page complaint against you. They file in federal court. Now you have to have an attorney admitted to federal court, which is sometimes double those admitted to state court. So then you're going to, and by the way, fraud is not reimbursable by your malpractice carrier. They're not doing a retrospective audit. They're suing you for fraud under the Organized Racketeering Act known as Federal RICO. So they're going to give you 100, they're going to have 100 complaints against you. 99 are going to be pure nonsense. But one's going to have some reasonable doubt from a normal person looking at this. So they're going to submit it to the courts. The first thing your attorney is going to do is they're going to submit a summary judgment for dismissal. It's nonsense. Get rid of it. This is just 99.9% nonsense. They're going to file to get rid of it, but the carrier is going to render an objection to the claim. You know that one little complaint out of the 100 that might have some reasonable doubt for a normal person? The judge is going to say, you know what, these 99 complaints are nonsense, but that one complaint, I think we should have a jury hear it because I can't make a decision from the bench. It's just too, on the border. Once you do that, the carriers have won because now you're looking at 3 to 5 years of attorneys, of paper, of depositions and documents back and forth and interrogatories, all this legal mechanism. You never even have an opportunity to say, hey, I didn't do that, or hey, I did this. You don't get to say that for 2 to 3 years. Once the carriers do that, you're looking at hundreds of thousands of dollars in legal fees because the carriers just want you to settle. Guess how many motions the carriers have lost since the January 1st, 2000, okay? And we're now right in the middle of 2024, 4.5 years. The carriers have lost 0 motion to dismiss. And I don't like talking in absolutes, but they've won 100% of them. So you don't want to get into that fight because when you do, after hundreds of thousands of dollars of legal fees, and they don't care if you have to sell your house, your office, they don't care what you have to do, your retirement plans, cash in your insurance policies, they don't care. It's a financial calculus on their part in their fraud for profit scheme, and they win. So you don't want to get there. So how do you create a patient-centered, objective, demonstrable scenario? Well, there's a piece of technology called Symverter, which I've talked about many times in this platform. And what that does is through X-ray, you get a biomechanical study of showing you exactly where the biomechanical pathology is, which we call subluxation. Why do I call it biomechanical pathology? It's not a philosophical issue. It's not that I don't love BJ or DD or a history, because it's something that the entire medical, and no, I'm not a medipractor. I mean, I've been accused of everything. I don't really care. But who's reviewing these things? It's usually orthos, neuros, neurosurgeons, or maybe other chiros that the insurance companies have hired. But usually it's orthos, neuros, neurosurgeons. And when they bring their experts in, they don't understand subluxation. But when you say biomechanical pathology, they understand it really well. They don't know it really well. They don't like to challenge you on what they don't know. It's not a subluxation because they're thinking in terms of medical subluxation. So by talking in terms of biomechanical pathology, and yes, we do a chiropractic adjustment, not a manipulation, but when you talk in terms of that, and you've got an X-ray validated piece of demonstrative documentation, it's now patient-centered. So I've taken that report to the insurance company's lawyers that work with State Farm, Liberty, and Geico. I sat with them and I showed it to them. I said, you know what? If we had this, we would never bring a lawsuit, ever. If in fact on your SOAP notes, if you have a diagnosis, a symptom, and a clinical finding, rarely would we bring a lawsuit against you. Those are simple, easy things to do. And by the way, X-ray, oh, I can't take X-ray, it's dangerous. That's nonsense. You need 500 cervical X-rays in one sitting to have less than 1 in 100,000 negative or adverse effect in the human body. 500 X-ray, 57 lumbar X-rays or thoracic X-rays in one sitting to have less than 1 in 100,000 negative effects or adverse effects, because you need 100 millisieverts of radiation, which it takes 500 cervicals or 57 thoracic and lumbar. Now, when's the last time anyone took 57 lumbar X-rays in one sitting? And never. I mean, I teach in multiple chiropractic colleges, medical schools. Never, ever, ever, ever. And radiation's not cumulative. That's not my opinion. That's not my opinion. That's based upon the American College of X-ray Physicists. I believe that's the name of the organization, and the published research, which has been out for years and years and years and years. So it's all nonsense. Oh, you can't take an X-ray without weeks of conservative care. That's another bunch of crap. According to the American College of Radiology, X-rays for just simple low back pain is now recommended. Forget the ancillary pathologies. Forget the choose wisely nonsense put out by the American Board of Internal Medicine providers, and which the ACA has adopted. It's all nonsense. It's all politically motivated. It just has no validity in our industry. None whatsoever. How many times have doctors picked up agenesis of the posterior arch of the atlas, or arthritices, which create a host of problems with bone spurs that are pointing in, and if you adjust the patient, you can hurt them, along with a myriad of other diseases that we see, okay? That's like saying to a breast cancer patient or a woman, we're not going to be doing a mammogram on you because you don't have symptoms of pain in your breast, or I don't feel huge lumps. That's absurd. That's going backwards 50 years, going back to the dark ages. So we need to look at these things and be responsible. But by doing that, you're making yourself bulletproof. Now, a couple of other things that make you bulletproof. One is timed elements. When you report modalities, a lot of doctors are reporting the whole minute units. In other words, 1 unit is 15 minutes. You need a minimum of 8. 2 units is 15 plus 8, which is 23. 3 units is 15, 15 plus 8, which is 38. So you're writing 23 minutes, 22 minutes, 16 minutes. Well, carriers right now have stopped paying unless you give them clock time. You got to give them clock time. So if you don't put the clock time down and you just put the whole minutes, carriers are already instructing their claims reps and they're programming the computers not to pay it. And I guarantee you that's going to be a future, not right now, it's going to be a future center for fraud. So you need to get ahead of it. I'm keeping you ahead of how not to get in trouble. Because I speak to the carriers and what's going on in there all the time. I read their EOBs. I speak to the claims adjusters. I speak to the lawyers. They're always looking for tomorrow's great fraud for profit scheme to get money back from you that you deserve. So all of these things are important. You need to get software that could do those things. The other problem, when you take your SOAP notes and you do 20 in a row and you hold it up to the light, the words are identical. There's no change in words, they're all the same. To me, that is a predetermined treatment plan. That's an issue. As a matter of fact, there's a software program out that's relatively new to the industry that's called EMR Chiro. I actually wrote it. It took me months. It took me about 6 months to write that from scratch. And one of the things we've done is make sure that they're all not the same words. It's really cool, by the way. I'm really excited about that because it's the only, let me rephrase that. It's the only program, or the first program that I know of, that was written and coded and programmed by a chiropractor for a chiropractic. I had to learn four computer coding languages and applications to actually write it up and deliver it. So I'm really excited about that. But nonetheless, there's a lot going on in the industry, a lot. And um, there are many triggers in your reports, and your reports have to be great. Things like vitals. Vitals are vital. If you have someone that their blood pressure was 200 over 160 and they had a stroke, and you didn't do perhaps a vascular analysis test like a Bier-Lejeune or a Mainz test or a Declines test, and they have a stroke, well, you know what? It just might cost you your license. And malpractice will defend you, but then if a licensure board gets it. So you've got to take vitals. And, it's funny, I had a patient back in the early 90s when I first opened up at a home office. She called me up, she said, Dr. Mark, I have a brutal headache and my neck, I can't turn it and I don't feel well. And I said, something's just not right. She was a little bit overweight, not in great shape. I said, go right to the emergency room, then come to me. She said, no, I'm coming to you. I said, no. She hung up, showed up on my driveway. I ran out to tell her to leave, stood up in her car, foamed at the mouth, fell in my arms and died. Right in my arms in my driveway at a home office. She had a dissecting aneurysm in my driveway. Well, the ambulance came. They took her to the hospital. The next day, I got a call from the medical examiner. Dr. Student, did you tell her to come in? No. I told her to go to the emergency room. If she did walk in my office, and if I didn't do vitals, and then she died, there was a good chance I would have been accused of wrongful death. And by the way, this was in the 90s when people really hated chiropractic. Okay, and the reality is, in today's day and age, with so much going on with stroke, if someone dies in your office, you stand that chance. For me, thank God, I had someone listening on the phone who said, "Go to the emergency room, don't come to my office." And the medical examiner called me up and exonerated me. I thought I was going to be arrested, be frank with you. But if you don't take vitals and someone has a stroke and dies, I mean, that's irresponsible on your part. You're a doctor. Being a chiropractor does not exonerate you from being a doctor of chiropractic. We're not bone schleppers. We're chiropractors. Yes, what we do is magical when we adjust a patient. It's incredible. It's wonderful. We do all these great things. However, we're also doctors. And you need to protect your patient. You need to know what's going on. And here's another thing. If you don't know, don't touch. If a patient has pain radiating down their arm or their leg, what's causing that? Oh, subluxation, bone on nerve. Well, there is no bone on nerve at the root level. We know that. It's at the facet level. That's a conversation for a different topic. Well, let's just talk about that. Where's the bone on nerve? There's a meniscoid which separates the two facets. When that meniscoid, or like a disc between the two facets, separates, the facets approximate. The nociceptors on there fire into the lateral horn. When it dislodges, it also affects the joint capsule, which are ligaments, where there's Pacinian corpuscles, which are your stretch receptors, Urafini corpuscles, which are your crimp receptors, and then you've got more nociceptors and then Golgi tendon apparatus, which all feed into your lateral horn. Then it spills over to the deep paraspinal muscles, which are your proprioceptors, which then through the piezo ion channels go back into the lateral horn, up the spinal thalamic tract, through the periaqueductal gradient, hits the thalamus, ping-pongs off the anterior signal to prefrontal cortex and motor cortex, the cingulate, the hypothalamus goes back efferently to the spine to disparate areas that cause spasm in different places, which is why you can't adjust regionally. You have to find the primary lesion. Subverta will do that to you, and that creates biomechanical homeostasis. That's where the problem's coming from. So the issue is, I forgot what the issue was. Radiculopathy. Where's it coming from? We know it's not bone on nerve. It's not the root from what we're looking at in biomechanical lesions or subluxation. We know it's not that because that's not the bone on the nerve. So I've gone through this litany with a myriad of doctors. If there's pain radiating down the arm, what's causing it? Oh, it's radiculopathy. I didn't ask you if it's radiating. I said, what's causing it? What is causing it? Do you know? Well, how do you know unless you look? You can start with an x-ray, but you're probably going to need an MRI. Since you don't know, you're just guessing. So when you want to send your family member, your mother, father, brother, sister, husband, wife, kids, to a doctor who's just going to guess what's wrong with you. Oh, I'm just going to guess, take these drugs. You know, we've castrated medical doctors for years, just horribly. Oh, all they want to do is drug them up to shut them up. Just give them drugs. Well, what's the difference between the doctor who's giving them drugs and you delivering a high velocity, low amplitude thrust called a chiropractic spinal adjustment when you don't know what's causing this? Is there a space occupying lesion or herniated disc? Is there a varices? Most of you don't even know what that is. Is there a myelomalacia? Is there a cord edema? Is there? You don't know. Is there a epi or is there an intradural or epidural tumor? You don't know. So if you don't know, what are you treating? You need a conclusive diagnosis before you treat. That doesn't make you anything but an incredibly good doctor of chiropractic. I've gotten more new patients as a practicing chiropractor, more new patients, by patients saying, oh my God, Mrs. Sally Jones told me that you found out what her problem was, that you did all these tests, you did x-rays, MRIs, you ordered a nerve test. No one else did this stuff and you knew exactly where it was. That was the core of my being busy, along with being good at what I did, but all of us are good at what we do. If you don't know, you don't touch. Is that easy? You don't know, you don't touch. What's causing the pain? You need a definitive diagnosis. You need a diagnosis, a prognosis, and a treatment plan. Then you touch your patient. All of these things set you up for predetermined treatment plans, for fraud allegations, for licensure issues. I can't underscore this enough. And you need to understand how to interpret MRIs. Right now, according to the evidence in the literature in a 2017 research article from Spine, there's a 43.6% error rate in general radiologists interpreting the normal morphology or the morphology of the pathology in MRI on spine. And by the way, according to myself and multiple neuroradiologists from Harvard, there's closer to a 95% error rate from general radiologists. Yet you're relying on it to be correct, because general radiologists are not neuroradiologists who spend an extra 1.5 to 2.5 years studying only brain and spine. So you should only have a neurorad reading your image. And you'd also probably don't understand the requisite slice thicknesses needed. There's protocols in ordering, and imaging companies cut the corners so that you don't have to, so that they can get your patient out quicker. They're doing less work. It's a blind item. So all of these things are tantamount to you being a better doctor, getting a more accurate diagnosis. I can tell you since 2012, let me just look on my computer, which is on this side of me. I'm sorry, I'm a nerd. I'm in front of 4 screens. As of today, from January 1st, 2012, that's 12 years and 6 months, we've gotten 1,954,730 additional referrals into the chiropractic industry because of concluding an accurate diagnosis, because of knowing how to interpret a proper MRI, and if there's a mistake, and explaining and teaching where the primary lesion is coming to lawyers, to medical primaries, to medical specialists. And I love reaching into the medical field because they see 95% of the population. We see between 7 and 10% of the population. A medical primary will get about 25 spine cases a week that they don't know what to do with. They're sending them to PTs. If a PT is the first provider, opiate use goes up 82%. If chiropractic is the first provider, opioid use goes down 55%. If a PT is the first provider for spine, disability goes up 313% versus chiropractic. If opioid use goes up, surgery and injections and all of those things go up 56%. PT is great. I love PT. For spine, they should be the second provider to rehab if you don't want to do it. For extremities, they're incredible. Let them work. They can be the first provider. Chiropractors do great work, but I send all my extremity work to PTs, and I keep all my spine work for me. The stats are important. The research, there's so much evidence in the literature sharing all of that information. There's so much. So what you've got to do is know the evidence in the literature. And there's a site called the U.S. Chiropractic Directory, www.uschiropractic or HTTPS, U.S. Chiropractic Directory. It's a really bad name for a research portal, but it's the most frequented website in our industry. It's gotten almost 23 million hits where people have looked at pro chiropractic literature. And it's all housed there and it's free. Just go. Read everything I'm telling you. It's all evidence in the literature. It's all there. So there's a lot going on, folks. There's never been a better time to be a chiropractor if you're willing to take your head out of the sand or out of your butt, okay? And really look what's going on. If you're struggling with getting new patients, give me a call. I'll put you on the right path. It's just easy. And it's about becoming a better doctor, not a better chiropractor, because chiropractic works so well that even the worst of adjusters get almost everybody better. It works incredibly well. But it's being a better doctor and how to position yourself and how to communicate it and explain it. And do not get caught in the crosshairs of the carriers of a licensure board with predetermined treatment plans. Follow my rules for every area you touch. You need a symptom, clinical finding, and a diagnosis. Hey, folks, listen, I'm Dr. Mark Studin. Thank you so much for spending some time with me and listening to me ramble about what's going on in today's marketplace with respect to chiropractic, reimbursement, compliance, documentation, helping people, preventing people from having really bad things go on. And I look forward to bringing it to you more and more. Thank you so much and have a great day.